Good morning, everyone. So, yesterday, what all we have done? We have completed the evolution of the Indian Constitution, right? Till independence, we have seen how it has evolved. I mean, before independence. And then we have started with the making of the Indian constitutions. The Constituent Assembly, which was formulated under which plan? CRIPS or Cabinet? Under the Cabinet Mission Plan, right? Under the Cabinet Mission Plan, and then it was constituted in November 1946. The first meeting happened on 9th December, we have already seen 1946, and then we have seen how the seats were allocated, how those the members were nominated or elected, isn't it? So those all things we have seen, right? The strength also we have seen, right? Right. So first meeting of the Constituent Assembly, which happened on 9th December 1946, and the Muslim League, they boycotted the meeting because they were not happy with this. Yes, they wanted a separate dominion, they wanted a separate state, they didn't want to be the part of India. So obviously the Muslim League, they had boycotted it. Initially they boycotted it and they insisted on separate state Pakistan. The meeting was attended by only out of 389 members. The meeting was attended only by how many members? 211, that's all. Because even the princely state did not participate. Muslim League did not participate. So we have seen around 208 seats were taken by the Indian National Congress, isn't it? So only 3 members extra. All the Indian National Congress people and some independents and all. But Muslim League boycotted it and even the princely state did not join. Right? Then obviously you need somebody to preside over the session, isn't it? Like who preside over the session of Lok Sabha? Who preside over the Lok Sabha? Who is the presiding officer? Speaker, right? So we need some presiding officer, some chairman kind of, who will preside, who will see that there is a smooth conduct of the business of the house, isn't it? So for that, Dr. Sachidanand Sinha. Yes, Dr. Sachidanand, see this question has come in this year and people made mistake even in this. Such a easy question and direct question. This year, if you go through 2024 paper, Polity, the questions were so easy and so direct. Very direct and very easy. And almost 18 questions, you see, 18, 19 questions. Easily, those all the 18, 19 questions, I can make it correct. So you see, 1/5 of the mark alone coming from Polity. And the questions were very easy. Every year, the Polity questions are such where you can score maximum. Polity is one area. So if you strengthen that area, your score will be really good. At least 1/5 of the marks you will get only from Polity. Isn't it? And they're very easy and still people, they made it wrong. Such kind of question. This very simple and easy question. Dr. Sachidanand Sinha, he was the oldest member and so he was elected the president of the Constituent Assembly. So obviously before the election would happen, what happened? They just nominated one person to preside over the meeting, and considering that who would be chosen, so on the basis of who was the oldest member, so that he will get that kind of respect from the assembly, so he was chosen. After that, the election happened for the presiding officer, right? The president of the Constituent Assembly, and in that Dr. Rajendra Prasad was elected, right? So he was the elected one. Remember, these small point of difference have a huge meaning, because the questions will come little bit, they will twist, and if you are not able to make it proper, you are gone. You will miss that question, right? And one question means 2 marks. If you make it correct, 2 marks will be added. But if you make it incorrect, 1/3 marks will be deducted, isn't it? So this is how, this is the winning strategy. be very focused while reading, very, very focused. And those minute differences, please take care of those things. So later he became the president of the Constituent Assembly, and then S.C. Mukherjee and V.T. Krishnamachari, they were both elected as the vice president, right? Then on 13th December, Pandit Nehru, he passed the objective resolution in the assembly. He passed the objective resolution. What do you mean by the objective resolution? Basically, it has contained all the ideas. It was basically a summary of the ideas, what the freedom struggle they wanted to imbibe in the constitution. So objective resolution was nothing but it was kind of a summary of the ideas which the freedom struggle they wanted to put it in our constitution, and which is reflected in our preamble, which is currently reflected in our preamble, right? So that is what the objective, that India will be a sovereign country, it will be a democratic country, the rights will be recognized to the people, civil liberties will be given, such kind of things was there in the objective resolution. So that is what reflected later on in our preamble, right? Objective resolution 13th December, and by whom? By Pandit Nehru. Who was he? He was president, prime minister of the interim government, isn't it? Prime minister of the interim government. So don't make such kind of mistakes. Dr. Rajendra Prasad, he became the president of Constituent Assembly, right? So basically the objective resolution is nothing but fundamental philosophy of the constitutions, which is reflected in the preamble of the Indian Constitution. Clarity? Then obviously you know the Muslim League, they wanted a separate state, and slowly, initially they did not join, but later on they joined it with the intention to create obstructions in the functioning of the government and Constituent Assembly, because they simply wanted some kind of obstructions, that's all. Then obviously with so much of resistance and so much of obstructions, finally the Congress yielded to the demand of Pakistan, right? We have seen the Mountbatten Plan was passed, which called for the partition of India, and finally we got independence, and this India Independence Act was passed, and this was the last act passed by the British government, right? So what changes it made? Princely states, they joined, and after Mountbatten Plan, the Muslim League joined the assembly. They told, okay, anyway, we are getting the partitions, they joined it, right? And then princely states also joined, because the Mountbatten Plan was that either the princely state, they will join India or Pakistan, no independence. So anyway, they came to know either we have to be with India or Pakistan, so we have to join. So they joined it, right? Then Indian Independence Act, they made some differences. What differences was made? Assembly was made fully sovereign. See, in 1946, when the Constituent Assembly came into being, it was still under the British. It was still under the British, isn't it? We didn't get fully independence, right? So now, anyway, the Indian Independence Act was passed. India is free and independent country. Now the assembly are fully sovereign, and then they don't have to take any ratification from the British government or so, right? It made fully sovereign, and assembly also became legislative body. So Constituent Assembly has a two function. One was constitution making, framing the constitution, right? Second was law making, right? To legislate or to make law. So Constituent Assembly has two functions. One, making of the constitution. Secondly, to make laws. When the Constituent Assembly assembled for making the constitution, who presided it? Dr. Rajendra Prasad. He presided over the constitution making of the Constituent Assembly. But when the Constituent Assembly were they assembled for law making, then who presided over it? G.V. Mavlankar, Speaker. He later on became the Speaker of independent India. When the Lok Sabha was constituted after election, then who became the Speaker? G.V. Mavlankar, right? So before that only, because he was handling the function of the Speaker. So whenever lawmaking function, it will be presided over by G.V. Mavlankar, who later on became the first Speaker of the Lok Sabha. And for constitution making, who will preside over? Dr. Rajendra Prasad. Remember, these are the small differences you should remember. Fine. So the Constituent Assembly has two functions, legislative and constitution making, and these two were performed on different date, not on the same date, like performed on a separate days. Thus the assembly became the first parliament of free India, Dominion legislature. Why are we calling it Dominion legislature? Why are we calling it a Dominion legislature? Is there any idea? Because 1947, after that we became independent. Because our constitution has not come into being. Still we were following which constitution? 1935, right? So that's why, and it was framed by whom? By the Britishers. So that's why Dominion legislature, right? Once the Indian constitution came into force, 26th January 1950, that is what we call as an Republic Day, right? Then we became totally sovereign. See, we got independence in 1947, but then we still had a dominion status for 3 years, till we became a republic, right? So these points are not probably everywhere given in the book. So this is where, you should make a notes of that. So we got a dominion status with the independence on 15th August 1947. We got what? Dominion status. Because why? Our constitution was not framed, and we became republic and fully sovereign on 26th Jan 1950, when the constitution came into force. And we accepted dominion status. Why? Because we wanted some kind of guidance from the Britishers. Because all of a sudden, because the way independence took place, it was not normal. It was very, very difficult, under very difficult circumstances. Because there was separation, isn't it? There was partition, and there was lot of bloodbath. So the situation was not normal. So we wanted immediately what? We asked the Britishers, you please hand over the power, and it will be a dominion status. We'll take some guidance, so that the transition can be little better. All of a sudden, if they would have left everything, it would have become very difficult for us to manage. So that's why we accepted. Though in 1930 only, Purna Swaraj resolution was passed. Purna Swaraj means complete independence, right? But in spite of that, we accepted dominion status in 1947. Why? Because of the situation. Partition, communal rights, it was very difficult to, because partition is not easy, right? You have to divide the asset of the company, country. Assets of the country will be divided, liability will be divided, a boundary has to be created, huge displacement of population. It was not easy, very difficult. So immediately what we wanted, you give us, transfer the power and give us dominion status, and you be with us to guide us. And because we didn't had our own constitution also, we were still following 1935 Act. That was the longest running constitution under the British, 1935 Act, from 1935 to 1950. Fine. Yes. So we have seen when the assembly made for the constitution making, Dr. Rajendra Prasad presided over it. But when for the law making, it was presided by whom? G.V. Mangalankar. And these two functions continued till November 26, 1949. Because this day the constitution was enacted. This day the constitution was enacted and adopted. So constitution making work got over. It got over. So that's why the Constituent Assembly had a dual function, one making of the constitution and one, it was like a mini parliament also, right? Or makeshift parliament, you can say. After the Constituent Assembly, the work was over, it became parliament. The same building, you know what we saw, the parliament building, same building was used for as a Constituent Assembly and parliament. Later on it became parliament, and now you have a new parliament, isn't it? So after partition, what changes happened? The number of seats came down. Out of 389, how many seats? 299, right? So almost 90 seats were given to Pakistan, East and West Pakistan, right? So 229 seats belongs to what? British province, and 70 seats was given to the princely states. Okay? They will not ask you the number, but then have some rough idea. Okay? Then in addition to that, the constitution enacting of ordinary law, the constitution also performed the following function. What function it performed apart from making of the constitution? It ratified India's membership. It ratified India's membership to the Commonwealth in 1949. So apart from making of the constitution and also law making, there were so many other functions the Constituent Assembly did it. Ratified India's membership to the Commonwealth. Tell me, what do you mean by Commonwealth? Yes, Commonwealth countries mean? That is United Nations, you are talking about permanent 5. Commonwealth. So Commonwealth countries were those countries which were the colonies of the Britishers. So after independence, it was free, you know, obviously if you want to join the Commonwealth countries, you can join, and if you don't want, you can leave. So the nominal head, the ceremonial head of that will be the British Crown. So basically Commonwealth countries were those countries which were once the colonies of the British, right? So after independence, it was on their will whether they want to join or not. So those who joined, they become part of the Commonwealth countries. And who will be the ceremonial head? The British Crown. But that doesn't mean that the country are not sovereign. It is like out of your own will you are joining Commonwealth. Just it was okay, they were the part of the British India once upon a time. Right? So like Australia, you have India. Just find it out who are the country part of Commonwealth. How many membership and all. Okay, just write it somewhere. You should find it out and tell me tomorrow about Commonwealth countries. I will ask you tomorrow. Right? So what it did, it ratified India's membership to the Commonwealth in May 1949. It adopted national flag. This you can remember the date, July 22, 1947. Right? So before independence. Before independence only we adopted national flag. Then we adopted national anthem and your national song on same day, 24th January 1950, just before the constitution came into force. So remember when we adopted. They may ask you in chronology. They may ask in the chronology. Like first national flag, it was before independence only, 22nd July 1947. Then you have in the month of May 1949, Commonwealth we ratified, and then we adopted national anthem and national song 1950, 24th January. And also it elected, the Constituent Assembly also did one more function, was that it elected Dr. Rajendra Prasad as the first President of India on 24th January 1950. So it all happened before 26th, right? Because we wanted the President of India when we celebrated our first Republic Day, isn't it? Because the Republic Day, who is the one who hoists the flag? It is the President. On 15th August, who hoists the flag? Prime Minister. Remember these all information, right? So Swatantrata Divas, that is Independence Day, 15th August. The Prime Minister hoisted the national flag on the ramparts of the Red Fort, right? And 26th January, it is the President who hoists the national flag where? India Gate, right? There only Rashtrapati Bhavan is there and India Gate is there. You have visited to Delhi? No? So may you get soon chance to visit Delhi as appearing interview for the civil services, and then you can visit. Okay? So these were the function. Remember that they may ask the chronology, right? So what was the duration of making the constitution? Duration, how much time did it take? It took too much of time, almost 3 years, to be very precise, 2 years, 11 months, 18 days, means almost 3 years, isn't it? Almost 3 years. And on 24th January 1950, the Constituent Assembly held its final session. Final session, 24th January 1950, right? But later on, it remained as a provisional parliament. Why provisional? Why provisional parliament? Not a true parliament or real parliament. What was the reason why it is called as provisional parliament? Because why it still be? So true parliament was created in 1952 after election, because the election happened in 1951-52. So you can say after the first election, when 1952, a proper parliament was created after the first general election, isn't it? So general election happened once the constitution came into force, means as per our Indian constitution, not as per the Government of India Act 1935 or so, right? So that's why it remained as a provisional parliament. True parliament was created where? You can say in 1952 after first general election. Okay, so first elected parliament in 1952. Clear? Everything clear? Then look at some of the provisions of the Constitution. The Constitution adopted, again this piece of information is also important. They ask the difference between adoption and enforcement. So when it was adopted, the Indian Constitution was adopted when? 26th November 1949. When they will ask you adopted and enacted, same, adopted and enacted 26th November 1949, but enforcement 26th Jan 1950. Remember these words, adopted and enacted, because it was already enacted, right? So 26th November 1949 we have adopted and enacted our Constitution, and during that time what was the provisions and how it was being constituted? 395 articles, 8 schedule, and there was 22 parts, right? Now currently how many parts? Now currently it is 25 parts, schedule is 12 schedule, and articles 465, and it keeps on increasing. But still, when you see the last article, still you will find it 395 only, because so many articles, what they are added as A, B, C, D, like that. Okay, last article still you will find 395 only. Additions they have done in the form of A, B, C, D, like that. But yes, schedule, it's from 8 to 12 schedule, and parts it has also been increased. See, one more important point here is that, see, some provisions of the Constitution pertaining to citizenship, elections, provisional parliament, and temporary and transitional provisionals, and short title, which relates with these articles, came into force on November 26, 1949 itself. So if the questions come, if the statement is like the entire Constitution came into force on 26th January 1949, that statement is incorrect, because some part of the Constitution came into force on 26th November 1949 itself, but major part came into force on 26th January 1950. That's why we call it the day of enforcement, right? But if the statement they give you the whole Constitution came into force, or the entire provisions of the Constitution came into force 26th January 1950, then it will be a wrong statement. 26, no. If the question is the entire provision, all provision of the Constitution came into force only when they will use the word only on 26th January 1950, then that statement will be incorrect, right? Because some provisions already came into force on 26th November, right, 1949. So be careful while reading if such kind of statement they give you. But if they simply ask the Constitution came into force on 26th Jan 1950, then that statement is correct. But when they say that all the provision of the Constitution came into force only on 26th January, then that statement will be incorrect, right? So that is how, see, prelims this is all about knowing the slightest of difference. Read the question statement very carefully, very carefully, okay? But many times don't interpret also, over interpretation. Sometimes, people will make so much of interpretation, in that way also they will make the question wrong. So you should know when to interpret in what way. Fine. So you can see that some provisions related to citizenship, elections and so on, it came into force on 26 November 1949 itself, but the major part of the constitution came into force on 26 Jan 1950, and that is what we celebrate as a Republic Day. Now, why did we choose 26th January 1950? When already on 26th November 1949 we were ready with our constitution. Why 2 months extra we waited for? We were ready, right? We could have made 26th November only as an Republic Day. Why we waited for 2 months? Because I told you this Purna Swaraj resolution was passed, and after that we hoisted the national flag on 26th January 1930. I told you yesterday. So since then we were anyway celebrating as a kind of an Independence Day, Purna Swaraj, a day of Purna Swaraj, complete independence. So that's why we chose that particular day, because we were, since 1930 we were celebrating. We were accustomed to that day. So that's why deliberately we chose, okay, the constitution is ready, but we will wait for another 2 months and we will enforce the constitution then only. Okay? So, because 26th January in 1930, Purna Swaraj Day was celebrated, 26th January, after the Lahore Congress session in December 1929. 1929 Lahore session passed Purna Swaraj, and we observed the Purna Swaraj Day when 26th January 1930. So since then we were celebrating it as the Purna Swaraj Day. So obviously we chose that as a 26th January 1950 as a Purna Swaraj Day or Republic Day. Clear? So this is what about the constitution, how the making of the constitution. Then there is also something related with the criticism. People have criticized the Indian constitution in a different manner. So till I hope you are very clear with the things. Clarity is there. You just go and revise. So why I am emphasizing on certain things? Because this is how the questions are being framed in your prelims. And also I am giving you so much of analysis so that you can write good answer in your means. If they ask such kind of question, you are ready with your answer. Now, criticism of the Constituent Assembly, why the Constituent Assembly was criticized. So these are the point of criticism. Not a representative body, not a sovereign body, too much time consuming. It was dominated by Congress, lawyer politicians, and dominated by the Hindus. So this is how these are the few points of criticism. Several people they have criticized in this manner. So the first point is that it is saying that not a representative body. Why? Because it was not directly elected. It was not directly elected by the people, right? It was indirectly elected. So indirect election is not considered to be a true representation. But then it can see every criticism can be countered. Every criticism can be countered. So people have criticized that it was not a representative people. It did not reflect the true will of the people because it was not directly elected. Now anyway, it was indirectly elected, one thing. Secondly, when election happened in 1951 and 52, 1951, 52, the first general election, all these people who were the part of the Constituent Assembly, they were all elected by the people then. It was not that any people was not elected. All of them were elected by the people. That means what? They had that kind of sovereign will of the people, right? That reflected that these people were popular leaders. So that's why they were elected. So who were the part of the Constituent Assembly? They fought election in the general election in 1950-51. and all of them, they got elected. So in that way you can counter it, right? Secondly, not a sovereign body created under the proposal of the British government. It was under the cabinet mission plan, right? Under the cabinet mission plan. So that's why they say that it was not a sovereign body, and whenever the meeting happened, they took the permission of the British government. Now it was just because, see, we adopted a dominion status, I have already discussed, because the situation was such, but in no way the British government dictated anything. It was just a formal ceremonial kind of head, because we wanted their help during a difficult situation. So in that way you can say it was just a ceremonial in nature, that we wanted the help from the Britishers, but otherwise everything was done in a sovereign manner, in an independent manner. There was no influence from the British government, right? Only for the paperwork you need the signature, and you need some kind of guidance, right? See, guidance is something different, and order is something different, isn't it? Somebody is giving you the command, somebody is giving you the order, you are obliged to obey the order, but you are taking guidance. Are you obliged to take the guidance? No. If you want, you will take the guidance, or if you don't want, you will not take the guidance. So guidance is not an obligation, order is an obligation. So that's why people say it was a non-sovereign body, but actually it was a sovereign body only, right? Then time consuming. So people criticize that we took almost 3 years to make the constitution, whereas US, which is much bigger than us in size, in terms of size, country, it took only some 4 months, but we took almost 3 years. Imagine 4 months and imagine 3 years. Now why did we take so much of time? Again, there is a counter criticism. See, India, in comparison to the US is a more heterogeneous society, and the transition of power was also smooth in US in comparison to India. They did not face the kind of problem we faced of partition, of communal rights, and moreover India is a very diverse country in comparison to US, isn't it? Further, we had a single constitution. We have a single constitution, both for center and state. Whereas US, they have a dual constitution. For center, different constitution, and every state they have a different constitution. In India, we don't have such kind of thing. That's why we took so much of time. So for every criticism, there is, see, these answers are not there again in your book. These are, you have to analyze and interlink. So what is the counter criticism? The counter criticism is that the US constitution, there is a dual constitution. Center, they have their own constitution, and every state they have their own constitution. Moreover, the complexity in US was not in a manner as was in India. India faced a very difficult situation during independence. There was partition, there was communal rights. Then there is huge diversity in India. We have single constitution for India, and for the entire state there is one single constitution. So because of these reasons, and we have some typical problems like caste problems, minorities problems. So these things were also been included. It is the lengthiest constitution. US constitution is not that lengthy. We are the lengthiest constitution. So definitely it will take time, isn't it or no? It will take time because of these issues we have discussed, right? So that's why it took so much of time. So see, there is a criticism, there is a counter criticism. Then it is said also another criticism is this was the Constituent Assembly was dominated by Congress. So again you see, obviously at that time Congress was a single party, isn't it? Single largest party, and Congress at that time it was called as Rambo party. Rambo party. Rambo means what? Multiple colors, isn't it? So people of different ideology, different viewpoint, they were in the same political party, Congress, because Congress was so much adaptable and so much accommodative. Congress party was very accommodative. People from leftist ideology, people from rightist ideology, people of centrist ideology, they all were there in the Congress. So Congress was such a huge body which reflected different viewpoints and different opinion, and it was a very accommodative political party. It accommodated various viewpoints. So it was not like, you know, everybody in the Congress was of same viewpoint, but it is accommodated. So that's the reason the initial years the opposition was very weak, because in Congress only everything, even the opposition means different viewpoint people were there in the Congress itself. So it was a body which was based on consensus. It did not wanted to impose certain thing on people. Later on, Congress saw the decline, and there was like a one party kind of a system, or one person leading the party, and the viewpoint of one person became very, very important. That is how that then Congress got fragmented. During Nehru time, it reflected so many political viewpoints and all. So that's why it was very accommodative. But after the death of Nehru, we have seen the decline in Congress, and the Congress also got split. That you will do in the post-independent history. The Congress got split. 1969. So that is the reason even it was dominated by Congress. The Congress was like a movement. It was not one political party, isn't it? I said you, it was a movement which amalgamated people of different views, different faith and different ideology together. Right, so that's why there was not much need of opposition during that time, because they themselves used to, you know, inside only they used to have debate and discussion, and they used to listen to that debate and discussion, and finally anything would come on the basis of consensus. It was not based on one person taking the decision. Right, so that's why you can say that Congress was a movement. It was not a political party, and it contains the people from different faith ideologies and different political leanings. Even leftist people were there, rightist people were there, centrist people were there, all were there. See, that's the reason we adopted, you know, mixed economy. We adopted mixed economy. We don't go for the totally communist kind of system. We did not go absolutely for capitalist type of system, capitalist economy. So somewhere in the middle ground, mixed economy, right? So some leftist tendency will be there, some rightist tendency will also be there, mixed economy. Of course, more importance was given to public sector units, that we will see later on, right? So it was more an balanced body. It was balanced body. That's the reason you can counter this argument. Then lawyer politician domination. Another problem which was criticized was that the Indian constitution is written in a very strict legal terms, and it is very difficult for a layman to understand. It is very difficult for a layman to comprehend and understand. That is also one of the problems of the Indian constitution, because it was dominated by lawyer people. So lawyer, you know how they complicate the things. It is very difficult. Legal matters, difficult to understand by a common people. That's why when you read the Indian constitution verbatim, you will find it very difficult. That is the reason you take the help of commentary on constitution like Lakshmikant, or for example you read Didi Basu or PM Bakshi, right? So who has simplified the articles and provision of the constitution. Otherwise it is difficult. Now they will use the word save. Save this clause. Save this clause so and so. Save means, you know what it is? Except. But when you read for the first time, what you will understood by the term save? Save means what? So in legal term, save means except. Except this clause. So when I was also reading initially, I found it very difficult. Why save, save, save? Then I tried to find the meaning of that. So it means except. Except this clause. So and so. Right. So because why it is written in a very legal terms? Because it was dominated by lawyer, politicians. But again, you know, counter the argument by that. So during that time, you know, law was the most lucrative profession. Why people learnt law, you tell me? Why so much of prevalence of law? Why? Everybody law. Mahatma Gandhi law, Dr. B.R. Ambedkar law, Sardar Patel law. Means almost everybody have done law at that time. What was the reason? Tell me something. What could you imagine? What could be the reason? Why law so much? See, we were under the British government, right? And British government used to formulate these laws and all. So Indians people, they thought that we have to study law to understand these British law, what they are bringing. So at that time, whosoever was intellectual people and who were contributing towards national struggle, they had studied law. Because only who have studied law, they will be able to decipher the British law, isn't it? What is there they are bringing in India, what is there they are practicing in Britain, isn't it? So that's the reason they learned, you know, most of these intellectual class, they wanted to study law, to understand what this foreign government is doing to us, what kind of law they are bringing, isn't it? So that's why whosoever intellectual class, law. And they were the one who actually contributed so much to the freedom struggle, because they understood, isn't it? Those laws they understood, and they knew that these laws are not good for us, right? Then another criticism is that the Britishers, you know, they criticized that it was dominated by Hindus. Now again, you know, it's a very simple explanation, because majority of the people are Hindus, right? In India, majority of the people are Hindu, 80% of the people are Hindus only. So it is very obvious. Whosoever will be, now you go to America, it is dominated by Christians. It is dominated by Christians or no? You in fact dominated what? Almost 100% they are Christian. Hardly anybody will be from other religion, hardly. So obviously in India, though we are a secular country, but then majority of the population is Hindu. So that is how the representation of the people will happen, right? Proportional representation. So obviously more people Hindu, so they will be represented there also. So it's a very foolish kind of criticism actually. Time consuming and all they can say, fine. But then these all are just for the sake of criticism. So with this, we have completed this chapter also, the making of Indian Constitution. Now let's see some question from the first two chapters. Clear everything? Good. So we have done the evolution of the Indian Constitution. Let's try to solve these questions. These all are from your previous year paper only, previous year questions. So the first question you see, the distribution of powers between center and states in India is based on the following act. Tell me the answer. The distribution of power, the distribution of powers between center and state in India is based on the following act. What is the answer? You tell me. Sandhya? See? Pakka? Lock कर दिया जाए? Yes, good. It is C. Government of India Act 1935. Yesterday we have seen, right? Federation. Center and state. Because the concept of central states came with the concept of federation, right? Don't get confused that it was 1919. See, 1919 there was provincial list and central list, but there was no talk of federation. No talk of federation. So, Government of India Act 1935, distribution of power between center and state, right? Otherwise, the people might get confused 1919, but actually it was 1935 when the constitution conceived federation. Federation only means there is division of power between center and state. The next question, which of the following portfolio was held by Dr. Rajendra Prasad in the interim government 1946? So this one we have not done in the class, but I expect you to that you have read the book. See, that is why I see prelims, you can thoroughly concentrate on Lakshmikant. These all informations are there. Because those people also, they refer Lakshmikant to frame the question. Isn't it? But at the same time, I keep on telling you, NCERT also you should study. Conceptual clarity is very important. But majorly, of course, Lakshmikant will help you a lot. So the answer is food and agriculture. Food and agriculture. So this is again very factual, very factual. Again, this kind of question, if you revise well, one book thoroughly you have revised and you have studied very well. See, these kind of questions, some people who have not studied it very well, they may miss out. But some, they have studied it very well, one book thoroughly. They will mark it and they will get a lead. This is how we get the lead. 1-1. This one probably most of the people will mark it correct. But this type of question will give you the lead. These are factual. If you have studied it, it's good. It will give you the lead. Now this is one mains question. Please take it down. Try to attempt this question. Try to write. The Government of India Act 1935 has deep influence on the making of Indian Constitution. Discuss. This was based on again on previous year questions paper in mains. So try to answer and then I will discuss. Government of India Act 1935 has deep influence on the making of Indian Constitution. Discuss. You written? Now next we'll see these two questions from the making of the Constitution. The first question you see, with the reference to Indian history, the member of Constituent Assembly, from the provinces were directly elected by the people of that provinces, nominated by the Indian National Congress and Muslim League, C, elected by the Provincial Legislative Assembly, D, selected by the government for their expertise in constitution matters. Tell me, what is the answer? Both of you? Sure? Yes, see. Yesterday only we have seen, right? So, directly elected, it is anyway wrong. Nominated by the Indian National Congress and Muslim League, wrong. Nominated by the princely states, right? And elected by the provincial legislative assembly, yes, indirect election, isn't it? Indirect election, they were indirectly elected. Selected by the government for their expertise, no, this is also wrong, isn't it? Correct? See, good. So you were paying some attention. The next question you see. Who among the following was the chairman of the Constitution Committee of Constituent Assembly? What is the answer? A. I know people will make such mistakes. C. Yes. Answer is C. How did you tell? How did you know? Did you read? Have you read it? No? Then guess. Why? On what basis you made the guess? On what basis? So answer is C, right? So that's why they had given this option to make the people confused. He was the chairman of drafting committee. Drafting committee. So there was many committees. You please go through the book. You will find it all. There was major committees. Major committee. There were Union Power Committee, Constitution Committee. Drafting committee was the most important. And there was provincial committee. Provincial committee was headed by Sardar Vallabhbhai Patel, who later on became the Home Minister or Deputy Prime Minister of India. And power committee and Constitution Committee was headed by Pandit Nehru, right? Drafting committee. So again, this is a very factual, but this is where, many people they'll make such kind of mistakes. That's why they had given first option only like that. But the answer is your C. So you have to be very particular. Chairman of the Constitution Committee, not a drafting committee. You will make an analysis, oh, Constitution Committee and drafting committee must be same, isn't it? So there, see, these minute differences you have to keep into mind. Fine, so we have done this. Yes, we can make it here, and this is the eraser. All right. So now what we will do is that we have completed the first two chapters. Constitutions also we have done, the function of constitution we have done. Now we will see doctrine of separation of power. Doctrine of separation of power. See, in mains they had asked this question, and even in prelims they had asked this question. But particularly you will not find in that conventional book, Lakshmikant and all. Directly they have not explained it. So you can take down the notes. So first take down the notes and then I'll explain. So doctrine of separation of power was proposed by French philosopher Montesquieu. Montesquieu. French philosopher Montesquieu. He desired that three wings of the government, that is legislature, executive and judiciary, the three wings of the government or state, three wings of the government or state, that is legislative, executive and judiciary, shall be separated into watertight compartments, shall be separated into watertight compartments. In order to prevent concentration of power, in order to prevent concentration of power of the state in a single authority, in a single authority. Yes, in order to prevent the concentration of powers of the state in single authority. The objective of this doctrine, the objectives of this doctrine is to prevent the state from becoming authoritarian. What is the objective? The objective is to prevent the state from becoming authoritarian, to safeguard individual liberties. So what is the objective? To prevent from authoritarianism, preventing the state from becoming authoritarian and protecting what? Civil liberty. Civil liberties, right? Safeguarding the civil liberties of the citizens. The theory of separation of power has now become one of the fundamental principles on which the modern constitutions are framed. Modern constitutions are framed. It is an essential aspect of effective functioning of democracy. It is an essential aspect of effective functioning of democracy. The Supreme Court of India has ruled that theory of separation of power is a part of basic structure. Is a part of basic structure of the Constitution. And this cannot be taken away even by means of amendment. This cannot be taken away or destroyed even by means of amendment by the Parliament. The US Constitution, the US Constitution, first time they have included, right? The US Constitution, which gave it constitutional basis. The US Constitution has given the constitutional basis to the theory of separation of power by including in its provision. Since the US Constitution provides for presidential kind of government, since the US Constitution provides for presidential form of government, since the US Constitution provides for presidential form of government, the theory of separation of power, SOP you can write, right, in short form. The theory of separation of power has been fully incorporated under it. However, it is not a watertight separation. Of powers, and it is also modified by the theory of checks and balance, and it is also modified by theory of checks and balance. Whereas the Indian Constitution, which provides for, parliamentary form of government, under which the executives are not completely separated from the parliament, legislature. They work in close association with each other. The executive and legislature, they work in close association with each other. Therefore, the theory of separation of power has been partially incorporated under the Indian Constitution. Article 50 of the Indian Constitution, states that the state shall endeavor to separate judiciary from the executive. Accordingly, the Parliament enacted CRPC, Criminal Procedure Code, which has separated the judiciary from the executive. CRPC, Criminal Procedure Code, was enacted by a law made by Parliament in 1973. Okay, 1973, which separated executive from the judiciary. The theory of separation of power is also found implicit, indirectly, in Indian Constitution, where Part 5 and Part 6 have been separated. The Supreme Court in Kannadasan versus State of Tamil Nadu, Supreme Court in Kannadasan versus State of Tamil Nadu in 1996. The Supreme Court in Kannadasan versus State of Tamil Nadu 1996 held that the Constitution incorporated theory of checks and balance. So this is kind of the notes will be there with you. I'll give you some more detailed explanation here. So you see the origin of separation of power. You can still, write the important points. The origin of separation of power, if I have to take it in from the ancient, as I always give the example from ancient history, so that you get an idea how things has evolved. So basically the Greeks, Plato, he talked about in his work, The Politics. He told that there should be theory of separation of power. So he told there should be three body, it should be executive, it should be legislature, and it should be judiciary. Executive means the one who executes the policy, legislature who makes the policy, and judiciary, if there is any dispute, they will solve it. So in India, if you see, in the ancient period where republican form of government was there, republican, particularly the early Vedic period, there was republican system, means they were basically the Aryans when they came, they were nomads, they were tribes. So tribal culture is always said, more democratic, because they will choose the Raja on the basis of election, like that they'll do. So there was some kind of assembly in early Vedic period we have studied. There was Sabha and Samiti, right? Sabha and Samiti kind of things were there. In movie also you would have seen, like Mahabharata and Ramayana, you would have seen assembly was there, right? Where Mantri Parishad would be there and all. So Sabha and Samiti kind of things were there. And they used to, anyway, it was a tribal kind of society, and they used to choose the Raja. So some kind of accountability was there, some system of accountability was there. Means if the person is not administering well, he can be removed from that position, right? So Raja was elected, the king was elected. But later on, when there was more settled life and big territories happened, like they were called as Mahajanapadas, then the power of the king increased tremendously, and Sabha and Samiti, they lost the significance. Now the king became very powerful, and there was nobody to control the power of the king. The Mantri Parishads were there, but it was only for the helping the king in the administration. It was not any kind of a check on the power of the king. There was no much system of accountability. You see, in the Mauryan kingdoms and all, they were highly centralized, and there was no much. So more powerful the kingdom, less accountable the Raja. So obviously how the Raja will administer or how the king will administer depend upon his will. There was no system of checks and balance. So obviously what will be at jeopardy? Civil liberties will be at jeopardy, right? The system will become more and more authoritarian. If it is not accountable, there is a tendency of developing authoritarianism, despotism, right? They won't listen to the will of the people, but they will do whatever they want. Arbitrary, right? Arbitrary rule. So in India, there was, if you have to say, there was some system of separation of power in the ancient period, particularly in the early Vedic, you can talk about. Later in the period of Buddha and Jainism, during that period also Buddha and Mahavira, he come from the republican form of state, princely state, which was more republic. There was other Mahajanapadas, but there was no republicanism, there was monarchy. Monarchy is hereditary in nature. But republic means it will be elected by the people. So there were some few even during Buddha period and all. But after that, we have not heard about republican form of system. Gupta period, Harsa period and all, there was not much. Even the Mughal period, but was totally monarchical, despotic rule. Despotic rule means where, the entire power is concentrated in the hand of the king, and king can rule as per his arbitrariness. That can be arbitrary. So in that only, if people are lucky, they will get some good king. Like Akbar, we say that he was comparatively good. That's why we call Akbar the Great. But there were people like Aurangzeb also. See, that is what I don't say, that is the history says that he was very fanatic and all. So there was no system to check the power of the king. So obviously civil liberties will be in a jeopardy, and this would be no system of accountability, no checks and balance. People cannot have the freedom of speech, expression. People may not have the freedom, right? So ancient period, it was said that Greece, during Plato and Aristotle, they talked about separation of power. In the 4th century BC itself, 4th century BC. Later on, in Europe, see Europe, why people always look up to Europe? Because Renaissance, that's we say social reform movements or reforms movement basically. Renaissance means awakening, new birth, new beginning based on scientific evidences, rationalism. Renaissance means rationalism, logic, thinkings and all. So that scientific endeavor, these all became mostly in Europe. We do have evidence that India had all these things, but it was not well documented. Later on, we have seen in the medieval period, there was an awakening in Europe, whereas in India, it is said that the period was quite backward during this period. You know, India was quite backward when Europe was awakening. The Renaissance was there in the 13th century BC, 14th century BC. Sorry, not BC, 14th century AD. So already, particularly in Europe you will see England. The democracy in England, probably England was the first country where democracy came. But democracy in England was more gradual. It was more gradual. There was not fighting and a revolution to bring democracy like it happened in India or in US and even in France. You have the French Revolution, you have the US Revolution, isn't it? And then India already we had so much to bring democracy. So United Kingdom was quite gradual. There was a monarchy. So you will, when you read the world history, you will come to know there was a monarchy, but gradually it shifted towards democracy, and shift was comparatively more smooth in comparison to other countries where there was revolution, bloodbath and all, civil war, lot of things happened there. But US, it was comparatively good, smooth. So it was John Locke. In the 16th century, he also talked about separation of power. But he did not give so much kind of explanation that how it will be implemented and all. It did talk about some form of separation of power. It did talk about there is executive, legislature and federative functions. He has given more importance to international relation. He didn't talk about judicial function also. Maybe in the executive function only he has talked about judicial. Then this Montesquieu, he was a French person, and he was fascinated by England. France and England both are neighboring country. If you see, you will go in the map and see France and England, they are neighboring countries. So the French, there was lot of authoritarian rule of Raja, king. Very authoritarian rule. There was not civil liberty as it was in England. So this French philosopher Montesquieu, he wanted some kind of a system better, like at least kind of England, where people enjoy more civil liberties, because there was more democratic setup. Parliament has already come into being, and some form of democracy started taking place there. At least there was parliament to question the king, limit the power of the king. So he gave this concept of practical concept, you can say, though the concept was being discussed in the ancient period, from the ancient period only, but why we associate the concept of separation of power with Montesquieu? Because he gave a more systematic explanation of separation of power and how it can be implemented. Then he gave that there should be there should be three organs. The three organs of the state, this is state, executive, legislature and judiciary, they need to be separated. Because earlier what happened, all the power in the hand of the king. King was the legislature, king was the executive and king was the judiciary. Though they would have created some department, but ultimate whatever the king wants, that used to prevail. So he said that no, all the power should not be concentrated in one hand. It should be concentrated in three different organs of the state: executive, legislature and judiciary. But what he said that there should be a proper watertight separation of power. But practically this kind of things cannot be implemented. You cannot say that judiciary is totally working in its own way, legislature. If there is no interaction, again it will become difficult or not. There has to be proper interaction. So the United States, in 1789, when it formulated its constitution, it gave practical shape to the theory of separation of power. So US is a presidential form of government. And what was the objective of separation of power? So that no single authority has all the powers. The power is kind of separated in three organs. Legislature will make the law, executive will implement the law, and if there is any kind of dispute between citizens and state or among the states or among the organs, whatever, they will go to the judiciary to resolve the dispute. To safeguard the civil liberties, and there should be a system of accountability. So that's why separation of power was important. So US adopted presidential form of government in which this is the president, this is president, or you can say executive, legislature and judiciary, that is the Supreme Court. But it is not in watertight separation of power. This theory is modified by a system of checks and balance. Means each organ will check the power of other organs so that no organs become authoritarian. They have to interact, isn't it? So how they do the checks and balance, you see. President to the judiciary, how it is checked. President appoints judges. How judiciary controls the president? Judicial review. There is a system of judicial review. So president will review the act of the executive. It is against the constitution, judiciary will declare null and void. That this order of president is absolutely against the constitution. It cannot, it should not be put into action. Null and void. Strike down. Now, how the legislature controls the executive? Tell me. Through the process of impeachment. Impeachment, or you can say removal of judges. Though the president appoints the judges, the removal can be done by whom? By the legislature, right? The legislature can pass a resolution and then can remove the judges. So this is how the legislature will control the judiciary. How the judiciary controls the legislature? Through the system of judicial review. Isn't it or not? Through the system of judicial review. If any act of legislature, if it goes against the constitution, it can be declared null and void. So you see, having a written constitution itself, or making the constitution supreme itself, is a kind of an solution to the problem of authoritarianism, because it is the constitution which is supreme. No organs of the government is supreme but constitution, and the judiciary has been given somewhere the power to see that everything is as per the constitution. But then the judiciary should not also become authoritarian. So it can be checked through the executive, and even the legislature can put a check on the judiciary. If the judges does anything wrong, they can be removed by the legislature, right? Similar way, if the legislature should not also feel that I am all powerful, people consent is there, so we can make any law. No, you have to, judiciary will see that whether the law is just, fair, reasonable or not. You can't make harsh law, isn't it? You can't make harsh law. Judicial review, right? Now, how the legislature controls the executive? Through the process of impeachment. If the president does anything which is violative of the constitution or anything anti-national, then it can be impeached by the Congress there, legislature, right? How the president controls the legislature? Tell me, in what way? The president controls the legislature through giving assent to the bill. Assent to the bill. See, if any bill is passed by the legislature, it cannot become an act unless and until signed by the president. Isn't it or not? So even the president can control the legislature. So everybody, there is a it is what? Basically, separation of power is nothing but checks and balance. Checks and balance. Understood till here? Now let's understand what is India context. Same. You draw like this. Same. Executive, legislature and judiciary. Executive, appointment of judges. Judiciary, executive, judicial review. Legislature and judiciary through the removal process. Judiciary to the legislature, judicial review. Legislature to the executives, impeachment. Executive to the legislature, assent of the bill. Same, little difference. Now what is the difference? I'll tell you. See, India is a India. US is a presidential form of government. Presidential form of government. India is a parliamentary form of government. Parliamentary form of government, right? Presidential form of government, there is comparatively more separation of power, or you can say complete separation of power. Here the SOP is partial in nature. Why it is complete? Because here you see the president, who is the executive, the Congress, which is the legislature, and judiciary, the Supreme Court. Executive, legislature and judiciary. They are quite, separated from each other. Each have a distinct function. In president type of government, the president is not part of the legislature. That we will do in detail when we will do the presidential and parliamentary form of government. So president is not the part of the Congress or legislature there. He neither attends the meeting. The president do not attend the meeting of the legislature. Neither he is responsible for day-to-day business. He is not responsible to the legislature. Means he do not attend the debate and discussion of the legislature. No. Question hour, such kind of thing is not there in Means the executive do not go and answer the questions there. So neither he attends the meeting nor he is responsible to the legislature. Only the legislature can remove the executive in extreme case. Extreme case. When the president does anything anti-national, then impeachment can be done. That too higher majority is required. 3/4 majority is required. So that is the only way to check the power of the president. Otherwise, every day he is not. So presidential form of government is the theory of separation of power is more incorporated, because executive is separate, legislature is separate, and judiciary is separate. Now in the parliamentary form of government, you see the executive and legislature, there is a close relationship with each other. The executive comes from the legislature itself. The ministers, they are very much part of the parliament, isn't it or not? Because a minister has to be a member of parliament. If he is not a member of parliament, maximum he can remain 6 months. Within 6 months, he has to become a member of parliament. Otherwise, he cannot remain a minister. Right? Either you become a member of Lok Sabha through direct election or indirect election, Rajya Sabha. But you have to be the member of parliament. But such thing is not there in presidential system. He is not. And also the government should have the majority in the Lok Sabha, in the parliament, particularly in the Lok Sabha or not. There should be majority, but such kind of thing is not there in presidential. Presidential, whosoever is the president, suppose now Donald Trump is the president of US. He is from the Republican Party, right? So whether in Congress Republican Party in majority or Democratic Party in majority has nothing to bear on the president. He is there for 4 years. Nobody can remove him. Means it is not depends on the majority of the house. But in India, whosoever the political party comes to power has to be the majority in the Lok Sabha and means Lok Sabha particularly, right? Then only the person will be in power, and minister has to be the member of parliament, isn't it? Such kind of thing is not there in US. So US there is little more separation of power. But in India, where we have a parliamentary form of government, there is a partial separation of power, partial SOP. Got the point? Why? Because the executive and legislature, they closely associated with each other. The executive is very much part of the legislature. I hope you got the point, right? And judiciary is of course separate here. They are also separate. So this is what the difference is. There is partial incorporation of theory of separation of power in India case, because we are a parliamentary form of government. In the presidential kind of government, the president is very much separate from the legislature. So there is more complete separation of power. Because here the executive is responsible to the legislature. It has to have majority rule and all these kind of things. Such kind of thing is not there. They are quite separately working. And minister has to be the member of parliament. There no. President, neither president has the membership of the parliament there, nor the ministers. Ministers, they are called secretaries there. And president can choose anybody as its secretaries. No need to be from the parliament. But here the person has to be from the parliament, member of parliament. If not, within 6 months he has to become member of parliament. Isn't it or not? So that is what the difference between presidential and parliamentary form of government. And therefore separation of power is more complete here. Here it is more partial. Now the Indian case, what separation of power we have? What separation of power we have? So article, see in India, as I said you, we have to study from the Indian perspective. This SOP is partial in nature, and it is also modified by the theory of checks and balance. Like each organ will checks and balance the other organs, so that no organs become authoritarian. Though executive and legislature, they are working in close tandem, but the legislature can control the executive, means government. If they pass no confidence motion, the government is gone. Similar way, the executive can control the legislature if they have passed any bill. If the president is not signing, again the bill will not become an act, isn't it? But anyway, since the president in India, you can say the president is more in the hand of the government, right? Because it is the government who brings the bill in the parliament, and it is the responsibility of the government to see that the bill is passed and it is signed, right? But in US, it is a bit different. Whatever the bill passed in the parliament, it goes to the president, and president is not dependent on anyone. He is full free to give sign or not, right? But then there is also some arrangement to see that the president give the sign. We will see all this when we'll do in detail. But of course, the power of the president, there is more. So in India, what are the separation of what the constitution say about separation of power? So separation of power, Article 50 is a classic example. Article 50 of the DPSP, it says that executive and judiciary should be separated. If not executive legislature, at least executive and judiciary should be separated. Why is it so? Because you see, during the British period, the executive, the bureaucrats, it was a bureaucratic rule, right? Bureaucratic rule. So these bureaucrats, they had the civil powers as well as judicial powers. They used to try the cases, even criminal cases. So obviously, you know, that's why these colonial bureaucrats, they were very powerful, very, very powerful. And you know, colonial power was like a police state. They were not worried about the welfare of the people. But since India adopted a constitution which is based on welfare of the people, we can't have such kind of a system, right? Arbitrary system. So first thing they told that in the DPSP, they told that the state should separate the judiciary and executive. So that's why in CRPC law was created, Criminal Procedure Code, which has separated the executive from judiciary. CRPC will not be taken up by any executive organization. Under the civil law, they can have some power, but criminal law, they will not have power. Executive have no power under the criminal law. It is only with the judiciary. Civil law, they can have some power. Like revenue disputes is being solved by the collector. That is a civil power, not a criminal power. Means he cannot pass the punishment and all. At imprisonment kind of thing he cannot pass. Fine and all things he can pass, but not imprisonment, such kind of thing. So imprisoning somebody, that relates with more criminal power. If you are passing a sentence. Particularly serious cases. If 1 or 2 day imprisonment, that is okay, fine. But you can't give them punishment of 5 months, 6 months, or 1 year, 2 years imprisonment. Even parliament, they have they can give they have some power to prison the people, give imprisonment of the people if they are going against the parliamentary work. Parliament, speaker, they have some power. But that is civil power, not the criminal power, not under the Criminal Procedure Code. So that is what it has been done, separation of power. What could be the other? Tell me, separation of power. Example of separation of power, Article 50. Then so what are the articles of the Indian Constitution that says that there is separation of power? Then part 5, part 6, that deals with your executive, legislature and judiciary. That also separate chapters are there. Executive, legislature and judiciary. There are separate chapters. Now tell me, what are the provisions which says that there is overlapping function? Overlapping function. In this you can also write Article 50, you can write Article 122, you can write. You check Article 122. Article 122 and 121. Article 122 and Article 121 also you can write separation of power. Article 50 I told you executive judiciary should be separated. Article 122 is that court cannot interfere. Court cannot interfere in the working of parliament. In the working of parliament. Court cannot interfere in the working of parliament. That is what Article 122. Article 121 is Parliament cannot discuss the conduct of judges. Parliament cannot discuss the conduct of judges except for their removal. Except for their removal. So it gives the independence, right? Article 50 says that judiciary is independent of the executive. Article 122 says that the parliament is independent of the court. Court cannot interfere in their working, right? Article 121 says that judiciary is independent of the executive. Means judiciary is independent of the legislature. Means legislature cannot discuss the conduct of the judges except for their removal. What does it mean? Means whatever the judges have taken the judgment, whatever the judges has given the judgment or whatever is their conduct, you cannot discuss them, cannot malign them, right? You cannot criticize them in the parliament because judges has to be held in very high esteem, isn't it? So you can't discuss that, no, this judgment was bad, the judges should not have given this judgment. Look at the conduct of that person, he is not a good judge. You cannot do all these things. Minister you can criticize, judges you cannot, except for their removal. If you are removing him, at that time their conducts can be discussed. Otherwise, day to day, no. Why this provision is given? To protect the judiciary from the unnecessary criticism of legislature, so that they are independent of each other, isn't it? Article 122 gives parliament independence from the judiciary. 121 judiciary from the parliament or the legislature. Article 50 executive independent from judiciary or judiciary independent from executive. These provisions you can write separation of power. Article 50, 122, 121, even Article 361 you can mention. Article 361. Article 361 is related to the provisions of president and governor. President and governor. So president and governor cannot be called in the question of law regarding their discharge of job, discharge of duty. Means you cannot question the president or the governor regarding how they are discharging their job. So this has been given a independence to the executive, the president or the governor, so that they should not be called in the question. Because see, what is the rationale behind that? The rationale is that anyway the president or the governor, they do not act on their own. They act on the advice of the Council of Ministers, isn't it? So if the president has given signature to anything or governor has signed anything, they should not be called in the court. Why did you sign this law? Because they act anyway on the advice of the Council of Ministers. So this way you can say the executive has also been given some independence. Because ultimately it is president and governor only will sign and they cannot be questioned for their duty. If you have to question, you can question the government. Governments are accountable. Government ministers are accountable, not the president and governor. President, in worst case, he can be impeached under Article 61, following proper procedure. That is the worst case. So you will get more and more clarity as you move in the class. Okay? So we have seen separation of power. We have seen what are the provision in the Indian Constitution which talks about separation of power. Then there are certain provisions of the Indian Constitution which say overlapping function. Overlapping functions means there is no complete separation of power. You give the example 72 you can give, article 123 you can give. What is article 72? Pardoning power of the president. Pardoning power of president. So you see this pardoning power of the president, see pardoning is a judicial act, but it is done by whom? By executive. What is pardoning? Like in case the court has given some harsh punishment, then president can provide remission, pardon, even death sentence he can pardon, right? So pardoning is something, it is a judicial act, right? But it is done by the executive. So this is a negation of separation of power, isn't it? Because executive entering into the domain of the judiciary. Then Article 123. Article 123 is the president making ordinances. Now ordinance is like a law. As yesterday only I told you, right? Ordinance is like a law. Then it is a work of whom? Legislature. But executive entering into the job of legislature. So there are n number of examples. Even Article 143 you can give. Article 143 is that 142. Article 142. That Supreme Court, to give the complete justice, can pass order. Supreme Court, to provide complete justice, can pass an order. See, passing an order is the work of the executive, not the judiciary. But Supreme Court, to do the complete justice, even ask the government to follow certain orders. So, judiciary entering into the field of executive. Isn't it? So, these are the provisions you can say which are overlapping in nature. Now, Supreme Court. What Supreme Court had said in India about the separation of power? So, Supreme Court said in the various act, first in the Ram Javaya Kapoor, Ram Javaya Kapoor case, 1955. The Supreme Court said that there is a separation of power in India. There is a separation of power in India, but it is not like it is there in US. Further, in the Keswanand Bharti case, Supreme Court said that separation of power is a part of the basic doctrine. Basic doctrine. Now, what is basic doctrine? We have seen briefly, I have already mentioned in the notes that basic doctrine are those doctrine which the parliament cannot change even by way of amendment. Like parliament can change anything by way of amendment or not, but they cannot change the basic doctrine, which is, and now this, what is a basic doctrine? That is basically enunciated by the judiciary. So in that way, judiciary has been made little more stronger, you can say. So in this, they said it's a part of basic doctrine, separation of power. Ram Javaya Kapoor, they said there is a separation of power, but it is not as kind of incomplete separation of power which is there in the presidential system, but it is more partial. And finally, in the Kanna Dasan case, we have seen Kanna Dasan versus State of state of Tamil Nadu, isn't it? 1996. They said that separation of power is there in the Indian constitution, but it is more modified by the system of checks and balance, right? And we are partial separation of power. We have a partial separation. So this is how already the question has come in 2019 means they had given, and prelims also they had given. So tomorrow I will show you that question and try to write in mains what answer you will be giving. Prelims we will discuss. Okay, so separation of power, just a recap. What is separation of power? What does the theory of separation of power says? That the power of the three organs of the state should be separated in three organs. It should not be concentrated in one organ, so that the objective of separation of power is what? To prevent arbitrariness, to prevent authoritarianism, and to protect civil liberties, right? To safeguard the civil liberties of the citizen and to prevent the state from becoming authoritarian. So in India, the Supreme Court had said, yes, there is a separation of power, but it is partial in nature. For the first time, separation of power was given a practical basis by the US Constitution, which is presidential in form, and there has been kind of a more separation of power or complete separation of power, but it is not a watertight separation of power. It is also modified by the theory of checks and balances. But comparatively, when you compare the Indian system with the US, yes, there are more separation of power because it is a presidential. In India, the separation of power is partial. Why? Because we are parliamentary form of government where the executive and legislature, they work in close association, right? They are not completely separated. And then you can write about what are the provisions of the Indian Constitution which talks about separation of power. You can write about the provisions of the Indian Constitution which negates separation of power. So we have seen, right? Like, what are the separation of power? We have seen Article 50, Article 122, 121, Article 361. I have given you some 3-4 examples. Then separation negates the separation or overlapping function, Article 72, Article 123, Article 142, you can give the example. And then you give the some Supreme Court judgment. In Ramjavaya Kapoor 1955, they said there is a separation of power, but it is partial in nature. Keswanand Bharti case, they said there is a part of basic doctrine and it cannot be amended. Whatever we have the separation of power, it should be there. Even though it is not complete, there is separation of power. And then in the Khanna Darshan case, 1996 also they said it is partial separation of power and it is more modified by the theory of checks and balances. So please go and revise because this you will not find in a proper systematic in one particular book. So that's why. So whatever the topic which is not there in Lakshmikant or here and there, that I will be dictating you. Okay? All the best. So we'll meet tomorrow. Okay? Please read and revise and try to answer the question I have given on mains. So try to answer. I know, see, as of now you will find it difficult, but see and write. It's okay. You read, you see, you write. Because answer writing, it takes time. It is gradual. It is not like, one fine day you will start writing and you will write a very perfect answer. It is a gradual. Then we'll evaluate your answer. We'll give you the feedback. Then slowly and steadily you will improve. You'll come to know how to write a good answers. Okay? All the best.